All right, Deputy Everett, are we ready?
Can you hear us?
Yes, I can hear you now.
We're ready.
All right, who do we have ready to go first?
Your Honor, I'm ready.
All right, State versus Dustin Lee Cook, CR 21209. And also, well, let's see, Mr. White, the case that you're on is, we call that case as well. CR 21162. That's the case that you're counsel on, I believe. Is that correct, Mr. White? The possession of firearm by felon 162.
Yes, sir.
Okay. All right, go ahead and I think you wanted to make an announcement.
Yes, sir, I did. I was speaking with Mr. Woodwag about the unindicted matters, and I had a concern after speaking with him that I may have a conflict. As he had indicated that on the matter which I'm counsel of record, that in the event of a conviction, that the state would be intending on trying to introduce the other offenses. After speaking with him, I went back and reviewed something in my file and realized that I might have a conflict. I've informed Mr. Cook of what I'm going to be doing. And I've also talked to Ms. Heisel about it. I'd ask the court reset this to October 11th, and I'll know then as to whether or not I do need to withdraw. And if I do, I'll go about what I need to do to make everything right with everybody.
Assuming that you don't withdraw, are you going to be representing Mr. Cook on the assault family violence matter?
Your Honor, I have not been retained on those.
Okay. All right. So any objection, Ms. Heisel, to the court resetting Mr. Cook's unlawful firearm by felon to October 11th?
No, Your Honor.
All right. Court's going to reset Mr. Cook's unlawful possession firearm to October 11th for status on, we'll just call that status on counsel, and also for docket call.
Yes, sir.
All right. And then Mr. Cook, you and I discussed CR 21209. Are you going to hire Mr. White or another attorney to represent you on that matter?
I'm working on.
Here, scoot you up a little bit. I can't really hear you.
I'm working on trying to come up with money to hire Ms. White. If that doesn't work, then I'm gonna have to probably go another route.
And I'm sorry, I can't hear you. All I heard was you're working on saving up the money to hire Mr. White, and if that doesn't work, I heard nothing after that.
I'm gonna have to go a different route. I'm not gonna have the money. If I don't have the money to get him, I'll just get a court-appointed attorney.
Well, that doesn't mean you're gonna get a court-appointed attorney. It means you might have to go hire another attorney.
Okay.
You understand? How much money do you have saved up now to hire Mr. White on the assault charge?
I don't know. My fiance's in charge of that, and we haven't communicated. She said she's got the money, or she's 1,000 short from having the money to retain Mr. White. So I have to give it her.
Well, I'm gonna reset this case to October 11th. When we come back, I expect to know exactly what you're gonna do on this case. I don't want to hear, I've got to find out. This person's in charge. This is your case, your life. You make the decisions. You let me know, so I know how to go forward. Okay.
Yes, sir.
No, that's all I have.
Thank you, Mr. White.
Sir.
Do we have anyone else that's ready?
Judge, I'm ready.
All right, Mr. Manning, who do you have?
We start off with Ms. Gonzalez.
All right. CR 2166, State versus Jennifer Lynn Gonzalez, set for pretrial. Go ahead, Mr. Manning.
Yes, Judge. Ms. Gonzalez has told me that she would like to accept the state's plea offer It's gonna be either an offer for probation or a time offer. I'm still working out the details with Mr. Woodwhite. And so I would ask if we can get her short set to next week. Once Mr. Woodwhite gets back, maybe we can get her taken care of and get her out of Henderson County Jail.
I'm fully booked, next week. Next time I can get you in would be on an uncontested docket would be October 11th. So that's what we'll have to do. Can you make October 11th or would you prefer the 13th?
Judge, I can make it work.
You can make which day work?
I can make the 11th work.
The 11th? Let me check something here. I think our trial for the 3rd got canceled. Hey, I tell you what, stand by for just a second. Let me check with Ms. Tabraham. We may have some availability the week of the 3rd to work and get her out sooner. So hang on, let me check.
Yes, Judge.
All right, Mr. Manny, do you want to stick with the 11th or do you want to go with the 13th? When
We'll
you're
stick with 11th, Judge.
11th, okay. All right, Ms. Gonzalez, we'll see you on October 11th.
And then I'm also ready on Mr. Quintanilla.
All right, Mr. Quintanilla, CR 21331. Motion revoked. Go ahead.
Yes, Judge. This is also one of Mr. Woodwhite's cases. I provided him some information about, I guess, mitigation for a offer. I've not received an offer in this case as of yet, but I've requested a resolution. And so I believe, once I get to talk to Mr. Woodwhite, we should be able to get this resolved. However, in the interest of efficiency, if we could get Mr. Quintanilla set as soon as possible, that way he can move on with his life one way or the other.
Okay. Do the parties want to agree to contest the docket a week from Thursday?
Judge, I believe this date can be ready, yeah.
That'll work, Judge.
All right, court sets Mr. Quintanilla for the contested hearing on September 29th. That'll be at 1:30.
Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Manning. Good to see you.
Thank you, Judge.
We have any other attorneys that are ready? Do we have Thomas Bailey in the courtroom?
No, sir.
Okay, I have Mr. Green available. He'll be Zoom. He's the only Zoom attorney that I see. The rest should be Mr. Schmidt.
And he's talking with his 4 clients right now.
And then Miss Lee. Is Miss Lee ready? She's only got Mitchell Gilbert.
Yes.
Deputy Everett, did you say Miss Lee's talking with her client?
Mr. Gilbert's coming out of the gym right now, and then she's right here and she's ready.
Okay, we're just waiting on him.
Miss Lee's gonna talk to her client for just 1 minute.
Okay, thank you.
Yeah, you are. We're just waiting on Richard, Spence guys, he's talking to them. They got 3 left. Should have 3 left, but.
All right, good afternoon, Miss Lee.
Good afternoon, Your Honor.
All right, this is CR 22-178, State versus Mitchell Gilbert. Is Mr. Gilbert there with you?
Yes, he is.
Come on up, Mr. Gilbert. All right, Ms. Lee, we are set for pretrial today. Are there any contested pretrial issues? Do you have the discovery?
Yes, no, and yes, Your Honor.
Okay, so if there's no contested pretrial motions, I would set this for docket call. Allow Mr. Gilbert and state to decide if they're going to work the case out and enter into a plea. If not, then on this next date, I would expect to hear jury trial or bench trial or plea, okay?
Okay, Your Honor.
All right, do you have your schedule with you, Ms. Lee?
Yes, I do, Your Honor.
Do you prefer October 11th or 13th?
Yes, I prefer October 11th, Your Honor.
October 11th, okay. All right, Mr. Gilbert, we'll see you back October 11th at 1:30
Yes, sir.
for docket call. Thank you, sir. And Deputy Ever, just let me know if we ever get Mr. Thomas Bailey in the courtroom.
Yes, sir.
He arrives and I'll bring his attorney in.
All right, sounds good.
Oh, you're a student. Okay. Get that. All right. Okay, I'll talk to you.
Ready? For what? Finished? Finished? That's fine.
All right, Deputy Everett. Is this Mr. Green's client?
Yes, Mr. Davis.
Okay. Let me bring Mr. Green in. All right, Mr. Green, we've got Mr. Bailey in the jail court, CR 1688 and 89. Set for docket call. Any announcements?
We do have an announcement. Been visiting with Ms. Curry about resolving Mr. Bailey's cases. She has made an offer that Mr. Bailey wishes to accept. We just need to get it set for a plea.
Okay. And is the offer for time?
It is, Judge.
Okay. Looks like I'm booked up the rest of this month.
You did set, well, he's in custody. I don't know if you want to bring him over to court to do the plea, or we'll do it through Zoom. What does the court wish to do?
Just looking at the next time I can get him in on a docket would be October 11th.
Judge, I'm set number one in Palestine in Judge Evans' court that morning for trial. And absent something unusual, I expect that case to go.
What about, I may be able to get him in on Thursday, maybe?
This
Well,
Thursday?
yes, I'm already 70 cases though.
I already have I've got setting that's going to create a conflict that I'm going to make work with you and Judge McKee that afternoon, but it's going to be we'll have to go to one and then go to the other. I prefer not to complicate that issue any further if we can avoid it. And there is one issue I do need a little time to talk to Miss Curry about. We've got to get the back time resolved, and then there's another issue I need to visit with her about.
So you're out that week of the 11th. So you're out the 13th also. You said you're number one.
I am number one, Judge, and I was just looking at that. Palestine is, I would think normally we would be done by the Wednesday, but Palestine or Anderson County is closed for Columbus State on Monday, so we're not starting till Tuesday. Normally we would start on Monday, but not that week.
What about Monday, October 3rd?
Works for me.
I think I'll create a day. We were supposed to have jury selection that day and that went away. So I think let's do that. We'll do October 3rd for plea.
At what time, Judge?
Let's just do 9 o'clock. Well, actually, no, he'll be in custody. So we'll do, well, it's not a docket day. So are you available morning or afternoon or one better?
I'm available anytime that day. I don't have anything set.
Let's just do 9 a.m.
At the courthouse or at the jail?
I'm sorry, Mr. Green. I'm sitting here setting things. I don't even know if I can get a courtroom that day. Matter of fact, I don't know. We're nomadic. I mean,
Is there some maintenance going on in the courthouse or?
well, it's just everyone's using all the other courtrooms, and so I don't have. So that's why I was in Will's Point today because they didn't have. JP2 was booked, county court was booked, county court of law was booked, the conference room, the library, the elevator was booked, everything was booked up. So,
Okay.
I don't know if I can set it on the 3rd. Matter of fact, let's just set it on the 3rd, and I will let you know where we're going to be.
Okay.
And if y'all want to get the paperwork done ahead of time, get all that signed and done, then we could do it via Zoom.
Okay. Sounds good.
And Judge, if it works for everybody else, if Mr. Bailey's gonna be the only person set on the 3rd, we could do it perhaps in the not the grand jury room, either the jury room of the 294th or the victim witness room, maybe.
Yeah, that's a possibility. I'm going to reach out to Mr. Manning. His client, I think I said on a little bit later for plea. So I'm going to reach out to him, and if he wants to change it from the 11th to the 3rd for Miss Gonzalez, I believe, then we may set 2 on that day.
All right, Judge.
All right, Mr. Bailey, we'll see you back October 3rd at 9 a.m. somewhere, somehow.
All right, y'all have a blessed day.
Thanks, sir. You too.
Maybe excuse your honor.
Yes, thank you, Mr. Green.
Thank you, Judge.
Good to see you. You do? Okay, good. Okay. So Ms. Barker says that we do have October 3rd scheduled for the county court if we need it. So that's probably where we can do the pleas if we need to. Ms. Heisel. I've reached out to Mr. Manning on Miss Gonzalez, Jennifer Lynn Gonzalez.
Mhm.
We had accepted a plea on October 11th. He said the 3rd would be good, so let's make that change. And we'll put her on the docket and we'll plea her on that same date as well. It'll save a week regardless of what she decides to do.
Sounds good, Your Honor. And I believe we're also going to have some witnesses in on the 3rd that were set for that trial that we're going to ask you to go ahead and swear and hold over. So we'll need to have space for them too.
Okay, good deal.
Thanks.
You're welcome. Mr. Schmidt, are you ready?
Yes, sir.
All right. Who would you like to call first, sir?
Julie Stifler.
All right, Julie Stifler, CR 22230. Understanding that Ms. Stifler wants to enter a plea today.
Yes, sir. Paperwork completed. We're prepared to go forward.
All right, Mr. Schmidt, can you give me the terms of the plea?
Yes, Judge. The terms are as upon a plea guilty, the state's recommending punishment be assessed to 5 years, TDCJ, suspended 5 years, $1,000 fine, and 180 restitution TPS liability.
How much was the fine?
1,000.
1,000. Okay, and you said 180 restitution,
Yes, sir.
290 court costs, any reimbursement fees?
$35.
Okay, and you're retained?
Yes, sir.
No 1245s?
No, sir.
Okay, and is that to the charge of possession, PCS, PG 1, 4 to 2,
Yes, sir.
2nd degree felony?
Yes, sir.
Okay. All right, Ms. Stifler, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, you can lower your hand. Mr. Schmidt, one more question. Was that the original indicted charge for Ms. Stifler?
Yes, sir.
Okay. All right, Ms. Stifler, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Bipolar schizophrenia.
Okay, are you currently on medication or undergoing treatment for that?
Yes, Your Honor.
Do you feel like you have a rational understanding of what's going on here today?
Oh, yes, sir.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with his representation of you?
I am, yes, sir.
And do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir, I do.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir, I understand all of it. Thank you.
Okay, and Mr. Schmidt, do you believe Ms. Stifler to be competent today?
I do, Judge.
And you've explained to her her constitutional rights and other legal rights as they pertain to this case?
Yes, sir.
All right, Ms. Stifler, I see that you've been indicted with a 2nd degree felony offense of possession of a controlled substance and penalty group 1 greater than or equal to 4 grams, less than 200 grams. A second-degree felony in the state of Texas does carry a range of punishment if convicted and sentenced to not less than 2 years in prison, up to a maximum 20 years in prison, and a fine, if imposed, not more than $10,000. Do you understand that range of punishment?
Yes, sir, I do.
And you heard Mr. Schmidt read the plea agreement to the court. He told me the plea agreement is you plead guilty in exchange for your sentence being set at 5 years in prison. It would be suspended today. You'd be placed on probation. You would pay your fine, court costs, restitution, and reimbursement fees. Is that your understanding?
Yes, sir.
And you read over your conditions of probation and you know what they say that you have to do.
Yes, sir, I did.
Knowing all of those things, you still wish to go forward.
Yes, sir, I did.
All right. Ms. Stifler, then I'm going to ask you, how do you plead to that charge?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
All right, and Ms. Heisel, at this time, can you give me the facts to support the plea?
Judge, if you'll give me just a minute, this is Mr. Woodwhite's case, but I will pull it up.
Okay. And Mr. Schmidt, if you want to do it, I'm fine with that. It's up to you. I don't expect you to.
And, if it makes Ms. Hazel happy, I'd be happy to. Offense, date of offense, March 6, 2022. Ms. Stifler was experiencing some vehicle malfunctions. There was a courtesy stop by the officer. Ultimately, there was some issues with plain view paraphernalia. A search was launched after that, and ultimately the controlled substance was found in her purse. And she was placed under arrest at that point.
In the drug lab confirmation?
Yes, sir.
5.13 grams of methamphetamine, Your Honor.
5.13 grams?
Yes, Your Honor.
All right, thank you, Ms. Heisel. Thank you, Mr. Schmidt. All right, anything further from the defense, Mr. Schmidt?
Nothing further, Judge.
All right, then based on the evidence presented, the court will follow the plea agreement as recommended by the state. Court finds there is sufficient evidence to convict Ms. Stifler. Court assesses her sentence in accordance to the plea agreement. Court convicts her of the second-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams to less than 200 grams. Assesses her sentence at 5 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence today, places her on community supervision for a period of 5 years, orders her to pay a $1,000 fine, $180 restitution, $290 court cost, and $35 reimbursement fees. Ms. Stifler, you're hereby remanded to the custody of the sheriff. To the custody of the Van Zandt County Probation Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over with the sheriff's deputy to be fingerprinted, and then you're gonna report to the probation department. Who's like next?
Jonathan Bergen, CR 22172.
All right, Mr. Burke. Is this also a plea, Mr. Schmidt?
It is, Judge.
All right, if you'll go ahead and read me those terms.
Judge, upon a plea of guilt, the state's recommending to the court that Mr. Bergen's punishment be assessed at 3 years in the Texas Department of Criminal Justice Institution Division, and that he be assessed $1,000 fine, $290 in court costs, and $20 in reimbursement fees. And he is given credit for 177 days that he's been in custody on this case so far.
All right. Mr. Bergen, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. You can lower your hand. Your name is Jonathan Philip Bergen, is that right?
Yes, sir.
And Mr. Bergen, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by Mr. Richard Schmidt. Are you pleased with his representation?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have your legal questions answered?
Yes, sir.
All of the paperwork that you've read and signed today, you understand what you've read and signed? Do you have any questions about it?
No questions. Yes, sir.
And Mr. Schmidt, do you believe that Mr. Bergen is competent today?
Yes, sir.
And you've explained to him his rights as they pertain to this case?
I have.
All right. Mr. Bergen, you are charged by indictment with evading arrest or detention with a vehicle, a third-degree felony. Does carry a range of punishment not less than 2 years, not more than 10 years, and a fine not to exceed $10,000. You heard the plea agreement that Mr. Schmidt read. Your plea would be guilty to that charge. State's recommendation to the court is your sentence to be 3 years confinement in TDC, plus that fine, court cost, reimbursement, with you receiving your credit time. Is that what you understand the plea to be today?
Yes, sir.
And that's what you asked the court to approve?
Yes, sir.
All right, Mr. Bergen, then how do you plead to evading arrest or detention with a vehicle, a third-degree felony?
Guilty.
You pleading guilty to that crime because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
State's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. And if I can hear the facts to support the plea.
Yes, Your Honor, I've got this one. Thank you, Mr. Schmidt, for the assist on the last one. Your Honor, on March 26th of this year, Canton PD located a Dodge Charger. They got a call from Henderson County that vehicle was evading them in Henderson County. They located that vehicle on Highway 19 here in Canton. They attempted to stop the vehicle. The vehicle failed to yield and ended up going down 19, down I-20, exiting to 64, going through Wills Point on 80, all the way to Terrell. At Terrell, the spike strips were deployed, and Mr. Bergen was the driver of that vehicle. Both him and his passenger bailed out of that vehicle. CPD let their canine officer begin tracking, where they located Mr. Bergen a short distance away, hiding in some grass.
Thank you. Mr. Schmidt, any objection to that summary?
No objection.
All right, anything further from the defense?
Nothing further.
All right, then based on the evidence, court finds that there is enough evidence to convict the defendant. The court will follow the plea agreement. The court convicts Mr. Bergen of evading arrest or detention with a vehicle, assesses punishment in accordance with the plea agreement at 3 years confinement in the Texas Department of Criminal Justice. Orders him to pay a $1,000 fine, $290 court cost, $20 reimbursement. And the court awards him 177 days credit towards his sentence for the time that he has spent in jail on this case. Mr. Bergen, whenever you get out of TDC, it's gonna be very important that you report to the courthouse so you can make arrangements to pay out what you owe. All right, your failure to do so will result in a warrant being issued for your arrest. Do you understand?
Yes, sir.
All right, good luck to you, sir. I'm going to have you step over to Deputy Everett, and you're remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence.
Right.
Who's next, Mr. Schmidt?
Christopher Edward Crutcher, CR 21-284.
All right, Mr. Crutcher also set for plea.
Yes, sir.
All right, go ahead with those terms.
Upon a plea of guilt, the state's recommending that they would abandon the enhancement paragraph contained in the indictment. Punishment be assessed at 3 years TDC, $1,500 fine. And also they're agreeing to take into consideration our 1245 Texas Penal Code, DA 2021-852, DA 2021-853, and DA 2021-854. In addition, I believe I said $1,500 fine, $290 court costs, $20 reimbursement fee, and Mr. Crutcher has 478 days credit time towards that sentence.
And you said state's abandoning paragraph, which one?
I believe there's only one enhancement paragraph contained in the indictment, and that one is abandoned. Yes, there's only one, Judge, so they're abandoning paragraph 1 enhancement. So we're proceeding on a second degree 2 to 20.
Thank you. All right, Mr. Crutcher, if you'll raise your right hand, sir, so I can place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, thank you, Mr. Crutcher. You can put your hand down. Your name is Christopher Edward Crutcher, is that right?
Yes, sir, Your Honor.
Mr. Crutcher, are you a United States citizen?
Yes, sir.
And you do read, write, and speak English, is that right?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir, Your Honor.
You're represented by Mr. Richard Schmidt. Are you pleased with his representation?
Yes, sir, Your Honor.
I feel like you have had enough time to talk to him about your case and have all your questions answered.
Yes, sir, Your Honor.
Is there anything about this paperwork that you've read and that you have signed that you do not understand?
No, sir, Your Honor.
All right, Mr. Schmidt, do you believe Mr. Crutcher to be competent?
I do.
And you've explained to him his rights and you believe he understands the same?
Yes,
All right, Mr. Crutcher, you heard the plea agreement that Mr. Schmidt read to the court. That's what you're asking the court to approve?
Yes, sir, Your Honor.
All right, so Mr. Crutcher, the range of punishment for an aggravated assault with a deadly weapon, a second degree felony, is confinement in the Texas Department of Criminal Justice for not less than 2 years and not more than 20 years, and an optional fine not to exceed $10,000. I would find that the proposed plea agreement you've reached does fit within that range of punishment. So understanding those things, do you still wish to go forward?
Yes, sir, Your Honor.
All right, so Mr. Crutcher, I'm going to ask you, how do you plead to aggravated assault with a deadly weapon?
Plead guilty, sir.
Are you guilty of committing that crime because you in fact committed that crime and you're not pleading guilty for any other reason?
Yes, sir, Your Honor.
And has anybody threatened, forced, or pressured you to plead guilty today?
No, sir, Your Honor.
Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
no objection.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
Nothing further, Judge.
Is there any victim notification compliance required on this one? So ag assault.
Judge. I know the state is in compliance, but let me check to see if we have received any response. Judge, it does not look like we have received any response from the victim in this cause.
Okay, you can give me the facts to support the plea.
Yes, Your Honor. On May 29th of 2021, Mr. Crutcher went up to the Edgewood Sonic where he had previously been an employee. I believe he had been let go either the day before or very recently to this offense before this incident. He got intoxicated and went to the Sonic to confront his former boss, the manager there at the Sonic. They went outside to discuss his firing, and there's some debate about the origin of the glass shard, but in any event, Mr. Crutcher picked up a shard of glass and started chasing the victim, the manager of the Sonic there, with the shard of glass. The victim was able to deflect using a trash can lid and run inside and call police. They located Mr. Crutcher a short distance away, whose hand was cut from the glass shard.
Thank you, Ms. Heisel. Anything further, Mr. Schmidt?
If I may, Judge.
You may.
Nothing further.
All right, there being nothing further than based on the evidence presented to the court, will follow the plea agreement in this case. The court finds that there is sufficient evidence to convict Mr. Crutcher. The court will follow the plea agreement and convict him of aggravated assault with a deadly weapon, impose a sentence at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,500 fine, $290 court cost, $20 reimbursement fees. The court dismisses under section 1245 DA 2021-852, 853, and 854. Furthermore, the court awards Mr. Crutcher 478 days credit for the time that he has spent in jail on this cost towards his sentence. Mr. Crutcher, whenever you're released from TDC, you're ordered to report to the Van Zandt County Courthouse to make arrangements to pay off the rest of the fees that you owe Van Zandt County. Failure to do so will result in a warrant and you being reincarcerated. I'm gonna have you step over with Deputy Everett so you can be fingerprinted and you're remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Go ahead, sir. Who's next, Mr. Schmidt?
This is David Lee Riddle Phillips, CR 21-305.
All right, Mr. Phillips. And is this a plea as well, Mr. Schmidt?
It is, Judge.
All right, go ahead.
Judge, upon a plea of guilty, the state's agreeing to proceed under section 1244A. State jail felony punished as a misdemeanor. Assessed punishment in 117 days in the county jail, $1,000 fine, 180 restitution to the DPS laboratory, $290 in court costs, $585 reimbursement fees. Mr. Phillips has 117 days credit towards his 117-day sentence.
All right, Mr. Phillips, raise your right hand, sir. Mr. Phillips, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Judge.
All right, you can put your hand down. Your name is David Lee Phillips, is that right?
Yes, sir.
And Mr. Phillips, are you a United States citizen?
Yes, sir.
And you do read, write, and speak English, is that right?
Yes, sir.
And have you ever been diagnosed with any mental condition?
No, sir.
You're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir, Judge.
And you heard the plea agreement as Mr. Schmidt read it to the court. Is that what your understanding of the plea agreement is?
Yes, sir.
All right, Mr. Schmidt, do you believe Mr. Phillips to be competent today?
I do, Judge.
And you explained to him his rights and you believe he understands them?
Yes, sir.
All right, Mr. Phillips, you are charged with possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony. The prosecution is asking to proceed under section 1244A of the Texas Penal Code, which means that if the court follows this plea agreement, you will be convicted as a felon in this case. However, your sentence will be that of a misdemeanor at the 117 days in jail with credit for time served. Do you understand that you will still be a convicted felon, but you'll be punished as a misdemeanor? You understand that?
Yes, sir.
All right, and I would find that the plea agreement does fit within the range of punishment for a 1244A. The maximum you could get under that 1244A sentencing would be 365 days, and the maximum fine you could receive would be a $4,000 fine. And you're receiving less in both jail time and fine in this case. So understanding those things, Mr. Phillips, I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram under section 1244A?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime, if for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
The court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing further.
Ms. Heisel, the facts?
Yes, Your Honor. On March the 10th of 2021, Wills Point executed a traffic stop for a vehicle crossing over the center line. The officer smells marijuana and questions all of the passengers of the vehicle. Multiple passengers admit to using marijuana. They also see paraphernalia in the vehicle. The defendant is a backseat passenger and he identifies himself as Lee Riddle. During the PC search, there's a defendant and another backseat passenger. And in that backpack, they find 0.37 grams of meth. The other passenger in the backseat says that it's the defendant's. defendant denies it's his. However, Wills Point searches the bag further and finds a letter addressed to David Lee Riddle in the backpack with the 0.37 grams of meth.
In that recitation, did you say who did you say the letter was addressed to? David Lee Riddle?
That's correct, Your Honor. Yes.
And our defendant's name is David Lee Phillips, is that correct?
I believe it's David Lee Riddle Phillips, Your Honor.
Is that correct? Is that correct, Mr. Schmidt?
Yes, Riddle is one of his middle names.
Okay, all right, thank you. Anything further, Mr. Schmidt?
Nothing further.
All right, then based on the evidence, the court does find sufficient evidence to convict Mr. Phillips of this offense. The court will follow the plea agreement and the recommendation of the state. The court convicts David Lee Phillips of possession of controlled substance of penalty group 1, less than 1 gram, imposes sentence pursuant to 1244A at 117 days in the county jail with credit for 117 days time served. The court orders a $1,000 fine, $180 restitution, $290 court cost, and $585 in reimbursement fees. Mr. Phillips, whenever you get out of the jail, I'm going to order you to report within 24 hours to the Van Zandt County Courthouse so you can make arrangements to begin paying the fine, restitution, court costs, and reimbursement that you owe. Your failure to do that and your failure to comply with paying these things will result to you being rearrested under a warrant and put back in jail. Do you understand, Mr. Schmidt?
Judge, I would note for the court that Mr. Alexander, I'm sorry, we have additional business to tend to with other counties, so it may be a minute before he's released. It's not likely to be today, Judge.
Okay, so whenever you are released, Mr. Phillips, then and you're out of custody, then you need to report over here to the courthouse to take care of this business. Do you understand?
Yes, sir.
Okay. All right, Mr. Phillips, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with Deputy Everett to be fingerprinted.
Yes, sir.
You have any other clients that are ready, Mr. Schmidt?
Yes, sir. I'm ready on Ryan Collier.
Mr. Collier? All right, this is CR 22-126 and 127, State versus Ryan Keith Collier. Was set for pre-trial, I believe, in each case.
That's correct, Judge. At this time, we're going to request that this be reset for pre-trial. There is some outstanding evidence that we're waiting on that we previously mentioned, and I know Ms. Hazel's working on that. And there's some other things that we've got going on, including some expert issues, but at this time, for discovery purposes, we'd ask for an additional pre-trial.
And can we just put on the record what the discovery issues are?
Judge, right now, yes, sir. Right now, there is a device known as a Zebra device, which is an electronic device that has an internal hard drive. It was listed as an exhibit, and I know for the record that when we were in last time, I put on the record the exhibit number in the police report that references. We are expecting, and I believe Ms. Hazel believes that information or the contents has been dumped forensically, and we're just trying to figure out where it is and how to get my hands on it.
Any updates on Ms. Heisel?
Yes, Your Honor. I contacted Wills Point Police Department and they told me that piece of evidence was forensically downloaded and that it was included in the materials that they submitted to the DA's office. We thought we had copied everything for Mr. Schmidt that we had. So at this point, we are going to go dig through what we have, see if we have it. If we don't, we're going to get with Wills Point because they assure us that it was done. So it's just a matter of figuring out which of the many thumb drives in this case that material is on and making sure that Mr. Schmidt has a copy as well as the state.
Okay, Mr. Schmidt, how long are you requesting for a reset?
Judge, if we could get that November date, that would be great.
Any objections from the state?
No, Your Honor.
All right, court will reset Mr. Collier then for pretrial on November 8th in each case. Ready when you are, Mr. Schmidt.
Esteban Mendez, CR 22-243.
All right, Mr. Mendez is set for arraignments.
Judge, at this point, we've received a copy of the indictment. Everything, Mr. Mendez's name is spelled correctly, understands what he's charged with. We enter a plea of not guilty, and for the court's note, we will be requesting a speedy trial in this matter. I've had discussions with Ms. Hazel as far as pretrial is concerned, that me and Mr. Mendez have sufficient time to go through the evidence, and I believe we're ready to trial. Obviously, the pretrial is statutorily required, but at this point, just so that the court's aware, we'd like to be put on the trial docket. Also, I've made Mr. Mendez aware of the time constraints pertaining to the size of the jury docket and the likelihood that that would happen immediately. Obviously, we know it wouldn't. And in the interim, I will continue to work with Ms. Heisel in an effort to resolve these cases. But from this perspective, we're ready to go.
And so did you say that Mr. Mendez has already reviewed discovery and he's had some sufficient time to do that? When it was this when did Mr. Mendez get the discovery prior to indictment?
Judge, we've had the discovery, I believe, at least, and that wasn't prior to indictment, but we've had it at least 30-45 days.
Okay. All right, then the court will set Mr. Mendez then for pretrial hearing on October 11th at 1:30. And then if there are no contested pretrial issues, we'll look at possibly scheduling this for trial that day. Not trial on that day, but scheduling for trial that day.
I understand, Judge. I understand.
And the court will find that Mr. Mendez has waived the formal requirements of arraignment, will enter his plea of not guilty into the record.
Thank you. Thank you. Thank you. Yeah. Talk to you soon.
Who's next?
Randy Alexander.
CR 18185, Mr. Alexander is on a motion to revoke.
It is, Judge. Just 1 second. Judge, we are set on a motion to revoke. At this point in time, we're not ready to proceed. Well, we'd ask for additional time. Obviously, if the court wants to set it on that contested docket, that's fine. I'd like to have an additional opportunity to speak with the state about resolution on Mr. Alexander's case.
I don't, if you wouldn't have 10 days if I set it next week. Do you want it set next week and wait 10 days, or do you want it set in October on the?
Judge, I would prefer an October date, to be honest with the court.
All right, court will set Mr. Alexander then for contested motion on October 27th. That'll be at 1:30.
Judge, we're waiting on the remainder. I think we have Robert Gerard and,
We got
Jennifer Culpepper and
Jennifer Culpepper.
oh no, we're getting, thing now. This is the Coffee County. Yeah, Robert Gerard and Culpepper. Yeah. Yes. All right.
Mr. Schmidt, I'm ready if you are. Is this Ms. Culpepper?
It is, Judge.
PR 21-352 for docket call.
It is, Judge. We received an offer from the state. We'd ask that this matter be set for a plea on that,
October 3rd.
Huh?
You want to do that October 3rd? Like, we kind of
Is it-
created the date.
Oh, did you? Oh,
We did, yeah. We had a jury trial that canceled, so I moved one of Mr. Manning's and Mr. Green's clients to the 3rd, so they could plead out sooner rather than later.
Well, we're not in that big of a hurry, Judge, but if the court needs that, that's fine, but otherwise we can do it on the 11th when I'm coming. Whichever the court prefers.
Is it a plea at a time or?
It is, Judge.
If it's all the same to you, I'd like to just go ahead and do it on the 3rd, and that way we can get her going. It'll save us a week.
Okay, that'll be fine.
Mr. Manning will be there that day. Just saying.
Is that gonna be at 1:30 or at 9?
No, we can do that at 9.
Okay,
We can do that at 9, have them brought over. So if he just happened to be there to do your plea, you know.
Thank you.
yes.
All right, and so we have Mr. Gerard. As he's getting ready to come up, we can go ahead and take up Cody Ledbetter, CR 22-186, CR 22-187, writ WR 2267. I'm not sure if council's aware, but we had received information from Kaufman County that Mr. Ledbetter was transferred to TDC on a 5-year sentence on September 15th.
No, sir, I was not aware of that. And I did speak with Ms. Heisel earlier about our writ. I know the last time we were here when it was originally filed, I asked the court to abate it, but obviously it's become a moot issue, so we can abandon that at this point. And perhaps me and Ms. Heisel can get together and work something out on Mr. Ledbetter.
Okay. All right, court will reset CR 22-186 and 187 to October 3rd for status. I'm sorry, October 11th for status. All right, and that leaves us with Mr. Gerard. And we're just waiting for him to come up, is that right?
Yes, sir. This is- Doing the original hallway. Thank you. I don't know if it's, yeah, I don't know if the substance abuse. Yeah. Oh, yeah, Mr. Brown. Can we do a problem with this? Well, after the, takes it away, kick me off because, because if you kick me off.
All right, Mr. Gerard, how are you, sir?
Doing good.
All right, CR 2267. I believe that we're set for 2 things. One, a pretrial, and also, Mr. Gerard, I believe did you file a motion to terminate, or did you just file a complaint against Mr. Schmidt?
Motion to terminate.
Okay. Before we take up the pretrial, go ahead and let's hear what you have to say, and go ahead and raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Go ahead, Mr. Gerard, tell me what the issue is on why you want to terminate Mr. Schmidt as your court-appointed counsel.
I couldn't get a hold of him for one thing. This is the first time I've seen him since I've been here a month and a half. Well, since the last court date, but I couldn't get a hold of him for like a month and a half. So I was trying to get another lawyer to tell me what I was gonna be facing today in court.
Is that the only issue?
Pretty much.
Okay. Mr. Schmidt, do you want to respond?
Well, Judge, my phone rings 24/7 from jail calls. We have a designated jail line. I think that me and Mr. Gerard was working pretty well together. I've got a lot of things in progress on his behalf. I do know that there was an issue with when his bond was revoked. He was obviously unhappy about that, and he would like to urge a request for a PR bond under the circumstances he's invited. And obviously, the court having revoked his bond, that becomes an issue. But you know, I'm perfectly happy working with Mr. Gerard. I think that we have an interesting case, and I think that he has some pretty valid defenses, but we've got a lot to do before we get there. And I'm having just a smidge of difficulty, I think, kind of explaining to Robert the timeline and the restrictions that we face, and I understand his frustration, but at the end of the day, you know, he's the one that's requested the court remove me from this case.
Mr. Gerard, do you still, you want the court to remove Mr. Schmidt as your attorney still?
I'm trying to, I don't know what I was trying to get a counselor in there to talk to.
And Mr. Gerard, let me ask you this. I can rule on your motion today. I can either grant it, I can deny it. You're always welcome to hire the attorney of your own choosing. You've asked for court-appointed attorney. Mr. Schmidt was appointed to you. Mr. Schmidt is a court-appointed attorney in this court. He takes a lot of appointments. He has a lot of retained clients as well. He's a very busy attorney. I know your case is not the only one he has, but he's present in court. He's ready on his cases. He has a good rapport with this court. I know he has good rapport with the majority of his clients. So you're always welcome to hire your own attorney. I can take your motion under advisement, and we can reset this, give you time to think about it, or we can go forward on it today.
I don't know. I don't know.
The first issue that we're bringing up is money. And then we'll address the second issue. So start with the first. The second one is, you know, I'm on bond, but you're here for a pretrial on your case. Yeah, so this is a separate. Your case is set for a pretrial, which that's what we talked about. Especially, so I see that. That's what I want to talk to you about.
Oh, okay.
I was going to use that to the court.
Okay.
But it's up to you what you want to do. You gotta respond to the
I'm
court. about
lost.
kicking me.
That's what I was saying.
I know, but you gotta decide whether you want the judge to kick me off. If you do, we'll settle that issue first, and then we'll move on to
I don't want to tell this. I like to work with you. I was just trying to
Okay,
get some
so-
counseling because
I can't come in here today, and I know it's been 30, but
Yeah,
I'm
yeah.
super busy. Judge, it's my understanding that we're going to proceed together at this point. Obviously, Mr. Gerard can re-urge his desire to terminate me in the future if he wants to.
Okay.
Remains his right. So as far as the pretrial matters on this case are concerned, as the court's aware, I've received funding from the court to retain experts on behalf of Mr. Gerard, which I have done. And we're in the process of scheduling time for the expert to meet with Mr. Gerard here. So from a pretrial perspective, I would ask for an additional pretrial setting on Mr. Gerard so we can take care of some of these issues. That would take care of today's hearing. I also know that Mr. Gerard has requested that we seek a bond reduction or a PR bond on his behalf. He has filled out a motion, a pro se motion. Obviously, the court will entertain that under the circumstances. What I would like to do on that is set Mr. Gerard for a very short period of time. We can file the motion on his behalf and give me an opportunity to speak with him about the bond reduction, perhaps even Thursday, or I think we have some time early next week, one of the two. But so from that perspective, ask for additional PR or pretrial, and then ask to take up those other issues later.
So Mr. Gerard, is that what you want to do?
But and he
No,
wants,
I wanted to do the personal, because my state's been robbed since I've been here.
No. Listen,
Or
I know, but
bond reduction.
I understand your issues on the bond, right? And I hope you understand my issues on the bond and why you're in custody today. What I want to know is, do you want to proceed with Mr. Schmidt or not? Because I still haven't heard yes or no from you. I heard what Mr. Schmidt said, that he believes you two are going to be able, that you're going to be able to accept him as your attorney and move forward, but I need to hear that from you since you filed this complaint against him.
I don't know, because I could not get him up here. I say no because I couldn't get him up here to talk to me ever. And I just asked for the bond reduction. I mean, he's representing me, so I was trying to push what I needed done so I could get out there and handle my business.
Yeah, I understand.
My state's been robbed since I've been here, so I'm sorry, I didn't mean to cut you off.
It's okay.
My state's been robbed since I've been in here. I don't want my evidence to go missing.
Understand what you filed this as a complaint.
Yes.
You've got to tell me what you want to do, and telling me I don't know and just tell me what you want, other than whether you want
Yes,
to.
we'll go and terminate now. I'll work on a lawyer. Or
Say it again. I'm sorry, I couldn't hear you.
you can go ahead and terminate our agreement, and we'll work on another lawyer, or I'll work on another lawyer. However.
So you're going to hire your own attorney?
Yes, sir.
Okay. When do you think you can get that done?
I don't have a set. I was hoping I had filed for indigency so I could have an attorney here today.
Well, Mr. Gerard, that attorney is standing there to your right.
Okay,
That is Mr. Schmidt. You filed for indigency. I found you to be indigent, and I appointed Mr. Schmidt to represent you. So now your option is either proceed with Mr. Schmidt as that court-appointed attorney that you requested, or you hire your own attorney. And you're charged with murder. So, you're probably looking at minimum $25,000 to start, I would guess, maybe more.
yeah, that's why I was requesting the bond reduction so I could get out there and get the money to do it.
Understand?
I
But right
don't have an attorney.
now the cart is before the horse, right? The horse is, do you want to stay with Mr. Schmidt as your attorney?
I'll have to, because I don't know how to represent myself right now. And then I'm working on a free will lawyer as well.
So you're telling me you want to continue with Mr. Schmidt as your attorney?
Yes, sir.
and Judge, at this point, I obviously, I would, without going on the record into detail, I would be put in a position under the circumstances to be working for Mr. Gerard, which I'm happy to do. But at the same time, Mr. Gerard doesn't want to work with me, but he feels like he's compelled to do that, right? Because of your financial
It's not that
situation.
I don't want to work with you. I have been robbed since I've been here. We got evidence that's getting stolen and stuff. I got a bunch of stuff that's getting read through.
I understand, but the problem is that putting in a position where you file complaints off, then you're allowed to, and it makes me uncomfortable because I'm trying to get it. So we have to decide how we're gonna go.
Well, that's all fine and dandy, but I don't have 25,000 to go get another. And
So you put. For you.
that's what I've already
You
done.
need to make that. I don't think.
I've already done that.
Okay. That's fine.
I just need some guidance here. I've heard you, Mr. Schmidt. I feel like Mr. Gerard has not raised a genuine concern that would require dismissal of you as court-appointed counsel. But if he doesn't feel like y'all have an attorney-client relationship and he doesn't want to work with you, then it kind of puts me in a situation where I have to decide whether if I remove you as counsel, I'm not sure that I have anyone else remaining on my indigent list that is capable of trying a murder case. And so,
Yes, sir. I understand the court's position. And I understand Mr. Gerard's concern. We would like to proceed, and I will meet with Mr. Gerard today, and we'll discuss how we get the rest of these issues tended to as quickly as possible. But we would ask to be reset for pretrial.
so what I'm gonna do, Mr. Schmidt, is I'm gonna take Mr. Gerard's concerns under advisement. That means, Mr. Gerard, I'm not gonna grant it. I'm not gonna deny it. If your concerns still persist in the coming month or months, then we'll talk about it again, okay?
All right.
And between now and then, if you decide or your family's able to hire an attorney and you feel more comfortable hiring your own attorney, you're always able to do that, right?
All right.
So I just want you to understand that. However, I don't really have any other court-appointed attorneys that I could give you that are qualified to handle a murder case. And so I would have to go out and, I don't know, try to borrow an attorney from another county who probably wouldn't be willing to do it anyway. Okay, and all I can do is tell you that Mr. Schmidt is a very well-respected and qualified attorney who has experiences in all levels of criminal defense and prosecution, from the highest capital murder to the lowest. Okay, and all I can do is tell you that you're not the only defendant that comes in and complains that their lawyer doesn't call them every day or write them a letter every day or come and see them every day. But the fact and the reality is these attorneys need time to do the work on your behalf, and they can't do anything for you if all they're doing is talking to you. So I want you to keep that in consideration, and we'll talk about that again in the future if your concerns persist, okay?
All right.
We're gonna reset this for additional pretrial for the reasons stated by Mr. Schmidt. Mr. Schmidt, how long were you wanting?
Judge, if I could, if we could set the pretrial for the November date, I'd also ask for a second date for Mr. Gerard, either Thursday or next Tuesday, so that we can take up his issues pertaining to his bond. And we'll have to file an additional motion on his behalf, but I know that that's first and foremost because he's in the position where people are taking the stuff. So if we could get 2 dates, I'd appreciate that.
Okay, so what we'll do is we'll set Mr. Gerard for a hearing. And I want to see a motion filed by you, Mr. Schmidt. I don't want to take up Mr. Gerard's pro se motion.
I understand, Judge. You'll have.
Otherwise it sets a precedent. They're all going to start filing their own motions and asking their attorneys to argue it. I will set it for status on motion to reduce bail. That'll need to be filed. I'll set that 9/29 on the contested docket in the afternoon. And then we'll set the case also for pretrial on November 8th at 1:30.
Yeah, no, so we're gonna come back, check this with, back to the pretrial on the actual case on the fifth. Okay, so this 9/29 is on, this is today. Okay.
Ms. Heisel, I believe that concludes our docket today. Do you see that I've missed anything?
Your Honor, that's all I have as well.
Thank you, Ms.
All right.
I'll be over to the courthouse shortly to make sure we got signatures on everything.
Okay.
Thanks.
All right. Appreciate you all. Thank you, Deputy Everett.
You're welcome. Thank you, Judge.
All right. You're very welcome. Thank you, Mr. Schmidt.
Thank you.
That concludes this episode of Have Gavel Will Travel. Please tune in next time. Same YouTube channel, same YouTube place. You have a great day.